believe the next section we talk about state licensing requirements, different states. Do you want to lead us in there, Brian?
Yeah, I'd be happy to, Emma. As we led off in the first segment, we talked about the fact that states regulate home inspectors tremendously differently. Some heavily regulated, licensed, others moderately regulated, may or may not even have a license, but there may be some statutory regulation. And then the third class is states that just really don't care. Literally you could print business cards up today and claim to be a home inspector tomorrow. And the problem is that as an inspector, no matter which one of those three kinds of states you're in that, you're lumped together with everybody else. You're all, quote, home inspectors. Your clients in California don't think there's a difference between a home inspector in California and a home inspector in New Jersey, but there's a huge difference in terms of licensing and statutory framework. So in your home inspection agreement, it's useful to do several things to make sure that there's a clear understanding of sort of the level of regulatory and licensing authority where you operate. One of the best ways is to incorporate by reference in your agreement the state laws or the state regulations or even the state licensing framework that applies to you. So if there is no licensing framework, you actually probably want your agreement to say, I operate in a state where there's no required licensing and where there are no state statutes or regulations that govern. So my home inspection agreement, the contract between you, the client, and me, the home inspector, is it. There is no third party information out there that controls what I'm doing. The flip side is true though also. If you're in a state where it's heavily regulated, you want to refer to that because by referencing those regulations, some of those actually state that home inspectors, only do certain things. So they can actually help protect you when they have a complicated, detailed regulatory or legislative, format in your state. But you want to make sure that that's referenced. The other thing you want to talk about is it's expensive when you go to court. It takes time, it takes money. I strongly suggest if you're in a state that supports what's called alternative dispute resolution, that you provide language that would allow you to either arbitrate or mediate a dispute. And if you're in a state that allows that, I would also use that to say that they have to arbitrate or mediate a dispute before they can take you to court. It'll save you a lot of time and money. And since time is money and you're busy, the longer a court case over a small amount or a large amount drags out, the more it's effectively costing you, in terms of your time that you have to pay attention and answer questions. So getting in front of a neutral third party, an arbitrator or mediator early on and talking through the issue while it's still relatively fresh in everybody's mind gives you an increased chance of resolving it for the lowest amount possible in the fastest time period possible. I would caution you that mediation on the part of the legal profession is often viewed as free discovery. Arbitration can be binding and enforceable in a court of law. Mediation really can't, unless you end up reaching an agreement that the parties then sign and becomes a settlement agreement. Otherwise, what you're doing when you talk to a mediator is you're telling them what your theory of the case is, and then the other side is doing the same thing. And so when you walk out of there, if you walk out without an agreement, the attorneys walk out knowing exactly what the other side is going to try to claim when they get to court. Not really sure that that is a great idea. I've seen mediation work, but I've also seen mediation, cause problems because if you don't get to an agreement, you just spend a whole day teaching the other side what your position is. And even though they say, what's said in a mediation can't be used in court, no, but what I learned in a mediation can. And if I learn what your mental approach is to defending a claim, then I can change my mental approach to attacking your defense. So be careful. Arbitration is much better than mediation, in my professional opinion. Other people may feel differently. And your insurance carrier may also want you to have alternative dispute resolution language in your agreement to make sure that keeps their cost of defending claims down as well. So there's a reason to do that. And then the last thing is, you could be a home inspector. I'll use it, what I call the tri-state region: Ohio, Indiana, Kentucky. So you can be a home inspector who's actually living in Ohio, who has an office in Kentucky, and who does home inspections in the tri-state area, all three areas. One of the things you need to decide as a home inspector is, if somebody comes after you, which one of those states have laws that help you best if you're defending a case in court, because you want to put in your home inspection agreement, this agreement is to be interpreted by the laws of blank state. Now, if you're only working in one state, then obviously that's the one state you fill in. But if you are working in multiple states, you need to spend some time probably hiring a local attorney who can say, if you live in Ohio and do inspections in Kentucky, Ohio, and Indiana, you probably want to use Indiana law because it may be, better for you at a defense standpoint than Ohio or Kentucky. I don't know these answers off the top of my head, and nobody really will, but it would be a good idea for you to spend an hour with the local attorney on that question, what's called choice of laws, because you want to have a choice of laws clause in your home inspection agreement, and you want to decide on the state that best protects you if you are working in multiple states. If you're a part of a franchise operation, that the franchisor may actually be able to help you, because they may have gone through sort of the same analysis when they picked which states they wanted to sell franchises in. Not that franchise law parallels home inspection, but they may have looked at the framework of how home inspection agreements and disputes are resolved in a state and said, okay, well, we'll sell franchises in that state because it looks like it's friendly for inspectors. We won't sell franchises in this state because it looks like it's more friendly for consumers. So if you are in a franchise operation, ask your franchisor if they did any of that research. But you definitely want to make sure that you have alternative dispute resolution and proper choice of laws in order to be able to reap the benefit of the legal system in terms of how to best defend yourself and how to best get rid of claims expeditiously and inexpensively, if at all possible. Kelly, you got anything else to offer on that? I know you've seen everything from mediation to major and multi-million-dollar verdicts.
Yeah. No, I don't really have anything to add, just to state that it's important to know what the standards of practice are and the laws in the states that you are inspecting in, and make sure that you're following them, because it could come back to bite you if you're not.
And that standards of practice reminds me of one other important thing, and that is, if you are operating as part of any type of a formal group, franchise or otherwise, and you're using their agreement and their standards of practice, keep in mind you better make sure that what you're looking at from them fits in with what the state requires of you. Because oftentimes, franchisors will come up with standards of practice that are very generic and apply to everybody who has their flag on their vehicle in every state. But each state has some particular nuances in terms of those states that have standards of practice, which might conflict with the documents given to you by your franchisor. It's incumbent upon you, as the professional running your own business, to spend some time finding out if the standards of practice that you've been given by your franchisor or your association dovetail with the standards of practice that are codified in your state. And if they're not, remember one thing: the state wins if there's a dispute. So make sure, and you may even want to go back to whoever drafted your form agreement and say, hey, that doesn't work in our state. You should have a separate agreement for all of us that operate in this state. That will help everybody if we could get some tweaks to these form agreements that pick up on some of the state differences to give you greater protection if you're a home inspector.
Thank you.
Agreed. Thanks, Brian.